My PowerPoint is evidence in criminal law. What is the purpose of evidence? It's so everyone can follow their rules of evidence because everyone is entitled to a fair trial. The rules of evidence, are also called the laws of evidence, are a set of regulations that act as guidelines for judges, attorneys, and law enforcement officials who are involved in a case. These guidelines are set in place to show how the trial should be executed, who can and can't be a witness, the rules to how that they can testify, how physical evidence at a crime scene has to be collected, make certain evidence is presented properly, and what evidence is admissible and not. The process and handling of evidence. The first step in the process is collecting the evidence from the crime scene. Officers should block off the area to ensure that no one contaminates the crime scene. Any type of physical evidence has to be collected, tagged, and marked to show what it is, date, where it was found, etc., and then packaged properly and transported to an evidence locker and be stored until it's admitted as evidence. The evidence must have a chain of custody to show every single person that has been in contact. It is on the government to assure and prove that the object is in the same condition as when it was found. Today, since physical evidence plays a vital role in proving guilt, proper storage is more important than ever. There is a property control officer who keeps a log of every item that enters the storage area and its location, and everyone who enters the storage and the items that were taken out. When evidence has to be delivered to the crime lab, the object must be wrapped and put in a sealed container with initials and a cover letter stating the object that needs to be examined and the type of examination that needs to be done. When evidence is displayed in court, there are several methods on how it is displayed so that others in the courtroom are comfortable with coming in contact with it and being passed around the courtroom. Relevant evidence is defined by the FRE 401 as evidence that has any tendency to make a fact more or less probable than it would be without evidence, and the fact is of consequence in determining the action. Material evidence is evidence that relates to a fact of issue to the current case. Competent evidence is evidence that is allowed in court, and incompetent evidence is evidence that is not allowed in court due to a number of reasons. The prima facie evidence is when evidence that stands by itself and goes unexplained or not opposed is good enough evidence to be accepted as a single fact or group of facts that establish the defendant or prosecution's defense. Contradictory evidence is evidence that is used to prove something or a fact that is opposite of what the other party or witness have said. Corroborative evidence is the opposite of contradictory. It's evidence that is supported by evidence that has already been shown. Cumulative evidence is evidence that is a repeat of evidence, whether it's from a testimony or tangible evidence. Admissibility of evidence is when the evidence can be introduced in the courtroom to the judge and jury to help them decide whether the defendant is innocent or guilty. Before it can be admissible, it must first be relevant to the case. Evidence is relevant when it proves facts and there is a connection between the evidence and facts of the case. Admissible evidence can be a document, tangible evidence, physical, or a testimony. Evidence can be inadmissible if it is unfairly prejudiced, wastes time, is misleading, and draws attention away from the main facts of the case and takes the trial off course. Other things that make evidence inadmissible is hearsay, expert testimony, and privileges. Privileged communication is when confidential information is exchanged between two people who are involved in a privileged relationship. Privileged relationships are very rare and limited because people can use it as an excuse to keep the truth from coming out during trial. In order for a privileged relationship to work out, the public must be highly interested and promote it. Sometimes these relationships are based on reason, meaning information is not disclosed because rules may prohibit. One must meet 4 conditions that have to be reached before someone is not subject to testify because of privilege. 1 is the parties to a communication must believe that their communication is confidential and will not be disclosed to others. 2, this element of confidentiality must be essential to the full and satisfactory maintenance of the relationship between the parties. 3, the relationship must be one which, in the opinion of the community, should be promoted and protected. And finally, the The injury that would cause to the relationship by the disclosure of the communications must be greater than the value of the conversation to the proper resolution of the court case. Privileged relationships can be between a husband and wife, clergy and communicant, news reporter and news source, psychotherapist and patient, parent and child, physician and patient, accountant and client, attorney and client, and law enforcement officer and informant. These relationships usually occur and are accepted when one person in the relationship can feel forced to lie than reveal the truth. Privileged evidence is evidence that is exempt from an opposing party in court because it's protected by statutory and common laws. Admissions and confessions. A statement is made by any party is an admission on the or other party's state, which can be used as evidence against them. A confession is a statement by the defendant consciously admitting to a crime. The difference between the two is with an admission, there are only certain facts being provided that can establish they may have guilt, and with a confession, they are admitting to the actual crime. In order for confessions and admissions to be admissible in court, they must be given voluntarily and not forced or being conned into it. An admission could be simply stating as you knew the victim or you were at the crime scene. The rules state that when the confessions are given by the person voluntarily and on their own, they have to be complete mental freedom and not have any pressure put on them, or else a confession cannot be used as evidence in the trial. To prevent confessions from being forced by police officers by pressure or abuse while a suspect is being arrested, this is where the Miranda warnings or rights were formed. As far as how confessions are worded, it does not matter if they answer yes to they killed somebody or they have a full admitting statement and explanation as to why or how. The confession can also be verbal or in writing, either is fine. And these are my references.